Welcome to the University of Michigan Dentistry Podcast Series, promoting oral health care worldwide.
In part one of this two-part series, we discussed the elements of a contract in some detail. Today, we're going to look at the contract in terms of its function and the various aspects of establishing a dental office and in the daily operation of the practice. Our guest is Daryl Negandank, an attorney and assistant professor of legal studies in the College of Business at Eastern Michigan University. Daryl, in our last program, we touched very briefly on the contract in terms of what contracts must be in writing. Could you amplify that just a little bit for us?
Well, you have to talk about various types of contracts. Let's first talk about patient care. What you're referring to is a very old statute we inherited from England called the Statute of Frauds. It really has nothing to do with fraud. Probably today you'd call it the Statute of Writings. It requires, in order for the court to look at a contract, whether it's enforceable or not, that there be some writing between the parties and signed by the party against whom enforcement is sought, the person you're going to sue. So if the patient wants to sue the dentist, then the dentist's signature would have to appear thereon. If the dentist wants to sue the patient, you have to have the patient's signature thereon. And the writing doesn't have to be a formal contract. It can be a series of memorandums, a series of correspondence between the parties.
What if there is no correspondence in absence of that? It's a verbal contract and then it cannot be heard?
Well, it depends. In the area of patient care, there are two rules. There are several rules under the Statute of Frauds. Two main rules. First one, if the contract is impossible to perform within 1 year, it has to be in writing. Because of the nature of dental services, most contracts wouldn't have to be in writing for the courts to enforce, because the question is not probable or what the parties contemplated, but sheer impossibility. So if you make out a long-term treatment plan and you and the patient decide that it'll take 18 months or 2 years to complete, the court will not look at what you decided upon. They'll look to see whether it was physically possible to complete. That is, if the patient came in every day and sat in your chair 8 hours a day, could you have completed the work in less than 1 year? Now, the area of orthodontics, you've got a problem there because of the long-term nature that it isn't possible to perform within 1 year. The court says it has to be in writing if impossible to perform within 1 year. Now, another aspect of patient care in regards to statute of frauds are promises by non-family members to pay for the services. The rule is the promise to a creditor made by someone other than the immediate debtor must be in writing. So your patient owes you for the services, but if you're looking to someone other than the immediate patient for payment, such as an aunt brings in someone and says, I'll pay for it, have to have that person's signature.
Does this include a guardian?
Clearly. Well, the guardian generally has a situation, like we mentioned before, that either the person has a mental disability or they're a minor. But in terms of non-family members, you better have their signature on something that promises to pay. Otherwise, as a creditor, you're not able to collect under the statute of frauds.
This could include anyone, a neighbor, a friend?
That's right. Oh, some neighbors worried because the person isn't receiving care. It generally has to do with immediate family, like an aunt would bring someone in. The well-to-do aunt wants to provide, pay for the services. I'm not sure it would occur too often. It's just something to be aware of.
While we're on the subject of payment, how does the Truth in Lending Act come into play here?
Well, that's federal legislation. Now, so far, the statute of frauds has been incorporated into state statutes. But now you're talking about federal legislation. And then the regulations that generally come with federal legislation to interpret them define a creditor as anyone who takes their payment for services in more than 4 installments, whether or not there's a finance charge. So if you agree to have payment made spread over extension of time in more than 4 payments, then you're subject to the federal Truth in Lending Act. Now, What does that mean? There must be complete disclosure. You must indicate if there's a finance charge. You can't bury it in. They're concerned about the consumer being aware of the difference between cash price and a deferred time price. What happens if you violate truth in lending? There are set damages set within the statute. The patient is entitled to actual damages. That is, they didn't understand there was a difference between cash price and deferred payment price. And then if they can show a pattern or a willful violation of the act, you can be subject to up to $10,000 in punitive damages, plus the patient suing the dentist would be entitled to his or her attorney's fees. So it could be a sizable amount if, in fact, you failed to comply with the Truth in Lending Act.
How does the dentist comply with this act?
Well, there are several forms to use, and it's clear if they can buy the idea, the patient can accept the idea. If you explain, federal law requires that, I fill this out and here it is. They'll have a set form that indicates the cash price, the amount paid so far, the finance charge, if any, how are the payments to be made.
What happens in the case of a dentist that does a normal billing at the end of the month for, let's say, a fee of $100, expects to be paid for that fee, and the patient responds by sending a check for $20 and saying, I will send you the next payment next month for another $20, and extends it out to 5 payments. That, in effect, puts you into these 4 payments, maybe against your will.
That's the key factor. You didn't extend credit, right? The patient chose to pay you over time against your statement at the bottom, all services are supposed to be paid immediately, or this we expect to be paid immediately, something to that effect on your billing statement. You should clearly indicate to the patient at the beginning that you expect payment for services immediately. And if you're operating on a cash basis, not a credit basis, then you should indicate to the payment that you are not in the position of being a creditor.
In your initial statement, you mentioned patient care contracts that extend beyond 1 year. To have this correct, how should the dentist execute such an agreement? Let's say the orthodontist. What should be involved in that agreement?
Well, you should clearly outline, the type of treatment that's going to be provided, be it orthodontics or, something else that requires more than a year, and clearly state fee estimate. I can't emphasize enough to say, make sure the patient understands its estimate subject to change. Have both parties sign it, each party keep a copy. You don't need a witness. Witnesses are something that they use, that's your notary generally, and it's for documents that are going to be recorded in the Register of Deeds office, or usually involving land. And so you don't need a witness, but you need to have both parties' signature on it.
If one party forgets to sign it or purposely does not sign it, is the contract invalid?
It's not enforceable.
It's not enforceable.
It's fine if both parties go along and perform, but if a dispute arises and you end up in court, you need the signature of the party that you're trying to sue.
What about the purchase of goods? Dentists buy a lot of supplies, expensive capital items to set up a practice.
All right. Now you bring in the Uniform Commercial Code that involves the sale of goods. Anytime the price of goods are over $500, the contract must be in writing to be enforced. So if you're talking about equipment for your office, it has to be signed by you to be enforced against you, and if you want to enforce it against the supply company, have the agent of the supply company sign. Now there's an exception to that, and that has to do with specially manufactured goods. You order the dental chair, and it's going to have, let's say you're left-handed, and you want this chair tailored to your own particular needs, so that you need to have this specially made equipment. Now, it doesn't matter whether you sign now, because if you have specially manufactured goods, and the supply company has begun even the simplest steps in producing the machine, the chair, and there's no ready market for the goods, then the contract's enforced against you, even though you never signed it.
Building and leasing contracts.
Well, now you're into another area of the law called real property law. And in that case, the rule for that is any interest in land must be in writing. When you're talking about leasing, the average person thinks in terms of I'm renting this space. The law looks at it as you're renting the ground underneath that just so happens to have a building on it. So it's an interest in land. Building contracts, same thing. Well, except that building contracts, it depends on who owns the land. You might fall in the area of saying that building contracts are like services that is possible or not impossible to perform within 1 year. Clearly in a lease, get both parties to sign, both the landlord and the tenant. You must have the signature of the other party in order to enforce the contract. That brings up another question often asked about lease in terms of buying a building, all right? That is, if you buy a building that there are already existing leases on, that are there existing tenants involved there, you must honor those leases until they expire.
So a new owner couldn't
evict
ask
everybody in
someone to-
sight.
yeah.
No, he buys it subject to the leases.
Up till now, we've been talking about the formation of a contract. I'd like to discuss with you the process of carrying out the obligation of the contract. But first, this message. Up to now, we've talked about the formation of a contract. How does one carry out the obligations of the contract?
Well, generally, the law will require full performance, whatever you agreed to do under the contract, the burden aspect of the contract. However, that's not quite fair in a lot of situations, so they'll take to a lesser standard called substantial performance. You don't know what that is until the court decides. You won't get your full contract amount back, but you'll at least be deemed not in breach of the contract. Now, there's another aspect that probably involves dentists, and that's the area of personal satisfaction. If the contract is of a nature that you're, worried primarily about personal skills contracts, then the standard for performance is to the personal satisfaction of the other party. That always involves an area of reasonableness. I keep using that word, but the law uses it a great deal. And that, in terms of the dentist, the person, for example, has dentures made. Now, if you say to the personal satisfaction of the patient, that's really too general because no one's completely satisfied with everything, or it's a rare patient that's completely satisfied with the dentures they receive. So the law will look at whether it's reasonable for them to object, and primarily the standards will be that which are used in the community of dentists where the person practices.
Orthodontists would run considerable risk in that because what the person would perceive as a satisfactory outcome might not match the treatment goals of the orthodontist.
I think this is probably an area where the crossover of the standard of care and the reasonableness and standards in the community comes in. That is, the criteria they would use in the malpractice area would also come in here for whether it's reasonable for the person to say, I object. Now, one area that would clearly be personal satisfaction is that's a contract with associates. That is, you no longer can work with this person. I don't care what the contract says. There's an element of personal satisfaction. I'm not personally satisfied, with this individual working with me, and that's clearly where the contract would be terminated at that point.
In terms of satisfying the patient completely, then you're saying that might cross over in the standard of care if it was to be contested in
I think
court.
so. They'll go by, what's reasonable, and how does the court know what's reasonable, and the only way is to get other dentists or other, a testimony to that effect, as to how would someone else have, did they comply with the standards in the community of dentists?
Surely there must be circumstances that occur where parties want to get out of a contract for whatever reason.
Clearly. Easiest way is when both parties agree. We don't want this contract anymore. It's called rescission. It's a mutual agreement between the parties. The law requires, in most of them, consideration. That little funny thing again. Now, one thing that consideration can be, and that's giving up of one's legal rights. And in terms of mutual rescission, or mutual agreement to rescind a contract, the party gives up the burden or the benefit he would have received. The dentist gives up her right to collect the fee, and the other party gives up his or her right to have the work done. So there's consideration to support it. Another one by which contracts can be terminated is what they call operation of law. Bankruptcy clearly discharges a contract by operation of law. So that if you have someone you've extended credit to, long-term treatment plan, and that person declares bankruptcy, I'll have to say that you're not going to be able to collect. The contract is discharged. Statute of limitations. You wait too long to sue on a contract, and that varies depending on the nature of the contract. Another way they're terminated is called material alteration. Now, I'm not sure how often that would apply in the area of operating a dental practice, but perhaps if you have a lease and you take your lease and your copy from the landlord and you start crossing out parts that you just don't like, and then later you attempt to enforce the lease against the landlord, saying you're not complying with this, he can argue material alteration. Next one, impossibility of performance. I mean, heaven forbid, but something happens that the dentist is not able to perform. Something happens to their hands, something happens to, more, involved, they're laid up for 6 months, they had major surgery. You have that aspect of the contracts discharged by impossibility of performance. This is an area where it makes a lot of sense to have a contract for mutual assistance, so that in the event that you need work to be continued on, orthodontic work, dentures, whatever, that you have a contract with another dentist that in the event that something happens that you can't perform, he or she will take on your patient for the completion of the work. Now, those require a lot of negotiation so that you know what percentage the person is paid, etc. And finally, all else fails, you can call the contract breach. I won't perform.
What is breach?
Non-performance of your obligations under the contract.
Against the other person's will?
Yeah.
They don't agree with it?
They simply talk about breach, the breaching party, and the non-breaching party. The non-breaching party who says, I want to have this contract performed. And the other party says, I don't want to do it. I want out of it.
What happens?
Damages. This is where you end up in your court of law, your civil case involving contracts, by which the non-breaching party seeks, generally, monetary damages. Damages in contract law fall into two main areas: compensatory, loss of bargain. You order this chair from the supply house for $1,500, and they finally come back and say, well, we're not going to deliver. You want that chair for $1,500. It costs you $1,800 now to buy an equal chair. You have $300 in compensatory damages, the loss of your bargain under the first one. The other area of damages in contract law are called consequential damages. Those that are expenses you incur as a result of the breach. It costs you several long-distance phone calls to find another chair just like it. You lost 7 or 8 days of operating time. These are consequential damages. The interesting thing about consequential damages is they must be foreseeable by the breaching party, the supply house who didn't bring your, deliver your chair on time. There's a real aspect of foreseeability. Again, it's like reasonableness. The court has to decide that.
With that thought in mind, if a dentist has a contract with a builder to have a dental office completed by a given date so that they can take occupancy and begin to generate revenue for themselves and operate their business, what happens with the new dentist that comes up to the circumstance where the builder says, sorry, we can't complete the building by that date, and the person is losing income daily?
A new dentist has a problem. Construction delays are generally foreseeable, at least the average person realizes you're not going to get in on that time. Technically, he's entitled to the loss of income as the measurement. The new dentist has a proof problem. His loss of income is speculative. Speculative damages will not be awarded. One way around that is to put in a liquidated damage clause that says, in the event of delay, so much will be deducted per day from the final payment. There's another area of construction contracts that you have to talk about in terms of the damage issue, is this brings in real property law. Every time you're talking about building something on a blade of grass, you bring in real property law. And much like the statute of frauds, it's developed over centuries. You're talking about real estate. Now, in terms of breaching construction contracts, you're talking about two people. The owner and the contractor can breach. Owner can breach at 3 times: before he ever starts working, before the contractor starts working, during construction, and actually after it's completed. Measure of damages if the owner breaches before the construction starts is the loss of profits that the contractor would have made. If he breaches during construction, it's loss of profits plus the costs the contractor has incurred. If he breaches after, that is when it's done, the owner says, I don't want it, I'm not going to go through with it, I'm not going to pay you, then it's going to be the contract amount. Flip the coin and make the contractor the breaching party. Now you have the contractor breaching during construction, generally what would happen. Then the measure of damages are the cost of completion. Contractor walks off and you have a half-built building. It was supposed to cost you $75,000 totally, and now it's going to cost you $20,000 to complete. So you pay the second contractor $20,000, all right? And I don't care how much the first contractor had incurred in terms of expenses, the most you have to pay him is $55,000, so that you are entitled to, you know, be made whole. The most you'll pay totally for the 2 contractors would be $75,000. The other area is what happens when the contractor uses material different from what you called for. Inferior material. You're entitled to the difference in value, the diminution in value. So that they, now this is again, you know, have a problem. You know, the building was supposed to be $75,000 and he's put in grade B pipes. All right, now if you can live with grade B pipes, you might only pay $55,000.
How would the dentist know whether the materials were up to the standard of the contract? Is it advisable to have someone inspect it?
Well, that's required by the code. The building codes generally require inspection.
Are you suggesting, by your example, that when you enter into a construction contract for a dental facility, whether it be to construct the entire building or leasehold improvements or whatever, that those materials be listed?
It helps. It certainly is helpful in terms of a proof problem. And see, lawyers think of, you know, they look at things retroactively. They want to prove everything. And the more ammunition you give up front when you contract, the more likely you will succeed if you end up in a court of law. Whereas most people think of take care of their affairs in a prospective manner.
I'd like to move away from the construction contract for a moment and talk with you just very briefly about associate agreements and the agreement between one dentist and another to practice together. Are those viewed as legal binding contracts, or how are they viewed by the court?
Well, they can be in breach. The problem has to do with the constitutional amendment, the U.S. Constitution, against involuntary servitude. You can never force somebody to work for somebody else, so that you can never get a positive injunction. Generally, they're almost a gentleman's agreement, except maybe in terms of how one splits the income from the office. That probably would be the enforceable aspect for services actually rendered in the times past.
But the associate says, I just don't want to work for you anymore. We've tried this out for a few months. I want to leave. The contract cannot bind him to stay?
That's right. You can never force him to stay. He might be subject to some kind of monetary damage, but you never can insist on him staying. It violates the constitutional amendment against involuntary servitude.
What about the owner dentist? If the owner dentist decides this individual doesn't, match personalities for whatever reason, and decides to terminate it?
Okay, he can be subject to monetary damages, but again, he cannot be forced to work with someone else. You know, the other person. Now, when someone leaves, you have that area of restrictive covenants. I talked about that before. You have a problem there, and if they're too general. This person shall not set up anywhere, or shall not be in competition with me, or shall not take my patient lists. Okay? if the restrictive covenant in the associate agreement is too narrow, is too general, the courts will strike it down. Often shows up in employment cases where they try and restrict the person from taking with them any information gained on this job. Courts are going to just look at that and say, forget it. Information gained on the job can be increased skills. It's too general a statement. So whenever you go into an associateship, even though you think, aha, this is going to be a great relationship, you should think in terms of what happens if we're going to end it. How do you get out of this? It should be written right into the associate agreement.
Are you suggesting that the associate dentist, upon termination of an agreement, has the right to the list of patients that he or she treated, and could contact them, notifying them that they are now in practice on their own? It
depends on how the wording of the initial associate agreement was. By and large, I'd have to say yes, depending, of course, on what restrictions there were in the written contract that was signed. If there's no written contract, okay, to start with, then yes, the answer, they can take a whole list of them with them.
In light of all of the principles that we've been discussing in this series, what words of wisdom can you offer a young dentist getting out of practice relative to contracts?
Well, obviously this program wasn't designed to make them lawyers. I assume they're watching this because they're going to be dentists. The idea is they have a good idea of the pitfalls to avoid. My feeling is they should seek legal advice. There are certain situations that they should have a little red flag that comes up in their mind and say, better be careful here. By and large, the more you know about how the law views things, the less likely you'll have problems in practice.
Thank you, Daryl, for your excellent overview on contract law. We appreciate it. Our guest has been Daryl Negandank, an attorney who teaches business law in the College of Business at Eastern Michigan University. Join us for other programs in the By Design series that keep you abreast of current topics and trends in the management of your dental practice.
You've been listening to a presentation from the University of Michigan School of Dentistry, which is dedicated to supporting open learning and open educational resources. This recording is licensed under the Creative Commons. It may be reused and redistributed for nonprofit use. Please attribute materials to the University of Michigan School of Dentistry and redistribute under this same license. For more information on how this and other University of Michigan School of Dentistry recordings may be used, visit www.dent.umich.edu/license.